Hi, I'm Jeff Whalley with Whalley Law. We are a family and injury firm here in Tacoma, Washington, and in Spokane, Washington. Today, I'm going to talk to you about motions again, and specifically family law motions. And how do I file a family law motion? And this actually is practical because family law has mandatory forms in which you can utilize to ask the court for nearly everything you can think of related to your family law matter. The caveat on that is there's always something extra that may not be included in the form, but you still can use the form to modify it in a sense of requesting the relief from the court. As this is a series regarding motions, I find that this to be very practical and easier to follow along. And so first, I will discuss, as I did in the last series or last video, the family law motions. And so what do we need for a motion? As we all know, Civil Rule 7 discusses motions and what you need. In family law, it is the same. It's the same rule. There are local rules for special proceedings, typically under 9404 in Pierce County. In other jurisdictions, it's about the same. And so make sure that not only you look at the civil rule, the state civil rule, but you look at the local rule as well in that venue or jurisdiction that you're practicing in or have a case in. And so first, I'm going to talk about kind of the nuts and bolts of the motion and what you need again. In family law, just like in civil law, just like in criminal law, you need all the same things. And these really are the primary documents that you'll need in every case. A note for a hearing, that is simply a scheduling mechanism. And so I will show you here momentarily what a note looks like and kind of walk through how to fill it out. But what it acts as is a scheduling document. And so in the note for hearing, you must also check with the court to verify that you are scheduling your hearing on the appropriate date and time. What you'll hear from a clerk or the court is you need to schedule it on the court's either calendar or the court docket. Every courtroom has a specific schedule in which either the commissioner or judge will hear a motion, or they will be in trial, or they'll hear just specific types of cases. One of those may be civil protection orders. There's a designated courtroom and docket in every jurisdiction related to civil protection orders. There are dockets that are specific to resolving cases and presenting final orders. There are dockets or calendars that are specific to finalizing orders or matters, like if you got a divorce, both parties are pro se. In some counties, they have a calendar strictly for filing a motion for presentation to finalize your divorce. All of those motions will need a note for hearing because that tells the court, this is when I want my motion to be heard, what day and what time. And then it also provides from there, you will then know what deadlines exist based on the local rule as to when you have to file something, when the other side has to file their response, and then again, when you have to provide your reply and make sure that all the documents are provided to the court timely. The motion, and I'm using a motion for temporary orders because it is most practical in this scenario and easiest, I think, and more elementary to follow along. Because in most cases, once you file your matter, whether it's a summons and complaint in civil matter, or that it is a petition for dissolution or maybe to change custody, you are going to ask the court for relief or something in the interim while the case is pending. The most common motion, and I think the court hears these in every jurisdiction nearly daily. There are some jurisdictions that simply only allow them on one day of the week, but typically those are smaller counties. But what they do is this is a motion that says, I need the court to make a decision on what the parenting plan should be while my case is pending, or who pays the debts while my case is pending. And so the note talks about when you're going to have the motion heard, right? And when you appear before the court, the motion tells the court what it is that you're requesting and what issues need to be resolved by the court. Then you're going to need a declaration, and this is included in CR7. You'll see it, that you need to have a declaration that supports your motion and to state with particularity what it is, the basis that you're asking for the relief. So why should the court grant the relief that you are asking for? And the declaration in family law, that typically comes in the form of a declaration of the party and also in exhibits to show the court that not only are your story true, but you have documentation to back that up. And so be very careful when you go through this process and you start drafting a declaration. That does not mean a declaration with anything and everything you have. And what I mean by that is the court has rules. Usually they're located in the local rule about how many exhibits you can attach to a declaration and how long a declaration can be, how many pages. If you want to exceed those pages, you would have to file a motion to exceed the page limit to be heard prior to your deadline for filing, so that way you can add the extra information. The court wants you to be concise. Please remember that. Provide enough evidence that it supports your position. The court does not want to see 300 pages of text messages. They don't want to see every email or social media post that's ever been made. They want to know what supports your request of the court for the relief that you're requesting. And that every type of law, that's what the court wants. You have to remember that these commissioner and judges have to read a tremendous amount of paperwork. Every day, they have to hear anywhere between 10 and 30 cases. And if you can imagine, page limits are typically somewhere around 15 to 20 pages per party. So they see about 40 pages per case. They're looking anywhere between 400 plus pages a night to review, to understand what's going on. So if you could be concise in your declaration and really provide them what you want and why you want it and the facts from those to support all that, that will increase your odds and your chances of being successful in your request. Now, if you don't always have exhibits, the next thing that can really help you and assist you in your request is providing declarations of others. And in the civil case, typically you'll need a declaration of an expert or somebody that supports the position. In family law, typically it's somebody who has knowledge of the issue. And just as a caveat and reminder, in family law, the court doesn't want to see a declaration from all your friends that talk about how great of a person you are. They want to see declarations from individuals who can be objective and who can say, on this date and in this particular incident, this is what I witnessed, to either present evidence of an issue within the parenting plan statute, so 2609187, RCW 2609187, those factors that the court have to look at in order to see what's in the best interest of the child. They want to see declarations that support those elements or those factors. And they don't want to see declarations that say, hey, John Doe is a really great parent and he should have full custody. And Jane Doe, she's not very nice, so she shouldn't have any custody. It doesn't provide any weight to the court. What is it? Remember, when you're looking at declarations and supporting declarations to give it, what is it that will compel the court to grant your relief? And then finally, one of the most overlooked aspects of filing a motion is providing the court with a proposed order. And why this is so important is because it is easier sometimes for a judge or commissioner to look at the relief requested in your proposed order and really narrow the issues, because they will see exactly what you're asking for and they don't have to read 30 pages of materials to determine what exactly you're asking for. And so it's kind of like working backwards in the process. But by providing the proposed order, you really perfect the process for the court, because the court commissioners and judicial officers, it's kind of like a cheat code for them to look at it and say, okay, are these requests supported by the declaration? And more importantly is, if you're not a very good writer and your declarations and motions are a little confusing, it provides them with more clarity, because they look at exactly what you're asking the court to sign off. This proposed order is what will be signed if the court grants it. And so they will look at that and make a determination. Is this relief supported by the law, case law, and by the facts? As I said, process makes perfect. And so knowing the process of filing a motion is very important. Make sure you perfect the process. Once you've perfected the process, it's a lot easier and less nerving to file motions. Now, that being said, do not continually file motion after motion after motion, because the court does not like that. In some jurisdictions, it is required to actually break up your motions because of the way they handle their documents. And so on the motion practice, they want to hear either the parenting plan or the child support aspect of the case. They do not allot enough time for both issues to be heard based on the way they run the calendar. And so it's important to talk to the clerks or the court related to how much time you're going to have to be able to present, how much, whether they're going to hear the matter with oral argument or if they just hear it on the written pleadings. Those questions are important, because as you draft this motion, you want to make sure that you're only providing them with enough information that it's going to be successful. If you present too much information, the court may not have the time to review it. It may end up resulting in your case getting bumped down the road. And so the relief you're requesting for the court is not timely at that point, right? You end up asking the court to make these rulings because you have something important happen. They don't have the time to hear it, or the other side doesn't have the time to respond because there's so much information. And so they ask for a continuance, and the process gets prolonged. So where do we file motions? Well, interestingly, in Washington State, we have many different filing systems. I do believe that the majority of counties now have gone to electronic filing, although there are some that still require in-person filing, which makes things a little more difficult at times. Here in Pierce County, we probably have one of the best systems in the state, referred to as Links. I'm taking a snapshot here. King County has its own system. Thurston County uses Odyssey, which is fairly common in the state. And Spokane County has their own system as well, which is a little different. And so it's important to look into this, because generally speaking, in this day and age, you can now create an account that allows you to file and receive all of your legal documentation through your email. And so making sure that you know how to utilize these systems is very important in filing a motion. So not only do you need to know how to create your motions, what documents you need, but then you need to learn, how do I file this? And how do I make sure that my motion, my note, my declarations, my proposed order all get to the right place? And that is can be troubling for attorneys as well. And with any electronics, there are always bugs and issues that come up with the ability to file something. Some documentations when you file will not be accepted by the filing systems because they are protected documents. So a lot of people now use electronic signatures. Sometimes if you do not resave that PDF of electronic signature, so it has the certificate on it, in a manner that removes the protective code or whatever it is, the filing system will not accept that document, and you'll get an error code, which can be very frustrating because you don't understand why your document keeps getting denied. And so if you're working against a timeline or deadline, it can be very frustrating. So plan ahead, look at the filing system, understand what that filing system is. We'll do a little mini series about the different filing systems in the state of Washington. But for the purposes of this presentation, it is important when you're drafting a motion to know how it's going to be filed, what the local rules are regarding the page limits, and basically taking that package and getting it delivered to not only the court and the judge, but also the opposing party. And so with Pierce County and links, you can see, and generally all counties now that have an electronic system also have this e-service tag or the ability to serve the other party. Now, that being said, you can only serve somebody electronically if they are part of the system. And in Pierce County, there's local rules related to whether or not somebody can accept electronic service. And if you're an attorney, you have to. If you're pro se, you can opt into it. In other counties, it's mandatory that everybody, whether pro se or attorney, opt into the e-filing. And that way the court can also send all orders and anything else that comes from the court or filed with the court through their e-service process. And so what does the family law motion look like? So I'm going to go through the forms, the mandatory forms, and these are available. If you just Google Washington Court Forms, the website, Washington Courts, provides forms that are mandatory, and you'll see right here, I'm switching screens. You'll see that down in the lower corner that you'll see that it's a optional form. And here, this language right here, Family Law All Forms 185, that indicates what that form is. And it will tell you that if you're looking for a specific form, these numbers sometimes are better than actually looking for notice of hearing. In family law, it's broken up kind of by what type of domestic case it is as to what forms you would use. And we can go into that in another mini series just to break down the different types of actions and what form would you use based on that action. And it's pretty elementary and straightforward, but it can be helpful because there are several different types of parenting plans that have very small differences contained within them. So here we have a notice of hearing, also known as a note for hearing, also known as a scheduling order in some cases, although most people believe scheduling orders or refer to scheduling orders that are issued by the court that tell you when things are going to happen. But in this is the standard state form. Up top here, the Superior Court is the court that you're in, the county of, and you would enter the county that you have your case in. Here would be Pierce. The petitioner, this caption here is generated by the court. And so you want to copy exactly what the caption is for your case. You don't change the petitioner, you don't change the respondent, those stay the same, and make sure you have the correct case number. If you do not have the correct case number, what will happen is either the clerks may miss it, which they typically never do, but if they do, it gets filed in the wrong case, or it gets rejected. And when you're working on deadlines, you never want anything rejected. So you want to make sure you have the right case number. It will be typically the year that it's filed, 24. The next digit is a 3, meaning a domestic case. If it's a family law matter, if it's a civil case, it'll be a 2. And then it'll be kind of the number of cases they've had. Typically is the way the jurisdictions lay them out. So the notice of hearing, you need to tell the other party and also the court that you're scheduling a hearing for a motion. And this section here says, is that I want to schedule a hearing on a certain date at a certain time. And then you need to include the court's address, the room. If you don't know the room number, it's okay. A lot of times people will put TBD, to be determined. In fact, the court does that at times. The most important part is the individual understands that you will be going to court on that day. In jurisdictions where you have a larger population, generally speaking, they will have several dockets and commissioners hearing motions on that day. And it just kind of depends on who's available and what the load is as to what courtroom you'll be assigned to. Other times there are specific departments that hear it, or courtrooms. And so if you don't know the docket, put it when you can. In Pierce County, the great thing about these notices is their link system actually generates one automatically. Will enter all the information for you. Just use the form. But in other jurisdictions, you have to create them yourself. And it's always better to understand how to do it and why you're doing it. So that way, even if you're relying on software or a form, you can see when a mistake's being made. Lastly, the most important thing is making sure that you sign this notice and that you include your service address and contact information on it. So that way, when the other individual is responding to your motion, they send it to the correct place, whether it be your email, if you opt into that, or your address that you want to receive this information. It is not an excuse to the court to simply say, I didn't get their response. Now, granted, a lot of times the court will give you the benefit of the doubt and continue the hearing, but the address that you include on the notice should be the address in which you are going to receive the documents. So do not add some other address that you're not going to get the mail at, and instead of your home address. And if you don't have an address, find one that's going to be the place where you get the documents. That's the most important thing. This area here is solely, as you can see, where you're going to accept the legal documents for the case. And so if you have multiple offices, you want to make sure it's the one that you always get the mail at. So a motion. How do we file that motion? What do we include in that motion? And again, family law, I think, provides a great opportunity to explain the basics of motions because of their mandatory forms. And so again, as you can see here, we have a mandatory form. It tells you down here the statutes that this mandatory form actually kind of relies upon and integrates within the form. It provides the form number here, Family Law Divorce 223, and the last version that this form is. And so in looking at this is a divorce form. And again, you're going to have the caption. The caption on your declaration, your note, your motion, your order should all be the same. If somebody's name changes, you should still mirror the caption. It is okay after you mirror the caption to write now known as, and then change the last name. That is okay. And that could be helpful, especially when we get into declarations, when somebody goes by a different name now, although the caption has their married name, to make sure that the judicial officer understands who you're talking about. This form here, again, the caption provides for a box to include a restraining order. With the motion, you typically have a header or where you're going to start, and then it gives you the rules of what you need to do for the motion. And that's why I think starting with the family law motion, it's helpful to those who are just learning how to file motions, whether it's a civil motion, criminal motion, or a domestic motion, because the mandatory forms provide some breakdown as to what you need to do. And in looking at it, you see to both parties, your papers must be filed and served by the deadline in your county's local rules. Remember, the local rules are very, very, very important. And so make sure that you review them before you start filing. Again, it gives you the web address to obtain the local rules and forms. And then it tells you what you need to do for the court to be able to consider your motion. As we talked about previously, you need to file your original documents. Now, again, originals are a little antiquated at this point because we all file, for the most part, electronically. And then you need to provide some sort of bench copies. In Pierce County, it's called working copies. On the commissioner's dockets, it's a Form T, but it provides the judicial officer with what is it in the file that they need to review and read to prepare for the hearing. And that is very important, because if you do not provide bench copies or working copies, then the judicial officer does not know what documents to look at. And unfortunately, they are overworked and do not have the time to review every single case on their docket in order to search out what it is you're looking for and what documents pertain to that request. So remember, working copies and providing clarity, concise statements is very appreciated by everybody in the judicial system. And then it gives you, again, read your local rules related to, as we talked about, as to what to expect at the motion hearing. There's some jurisdictions that will hear the pleadings only and not allow oral argument. There are some motions that will be for a commissioner or a judge, and there'll be time limits. They're 5 minutes, 10 minutes, or 20 minutes, depending on the type of motion and what judicial officer is hearing it. And so it's important to understand what to expect when you file that motion. And something that I would suggest to everybody, especially this day and age, is popping into a courtroom that you're going to have a motion heard in and via Zoom, and just observe and see how the judicial officers handle their calendar, the questions that they ask, and the mistakes that they point out of other people, because it'll only improve your odds when filing a motion. And so the great thing about family law motions too is, and we'll talk about it, how to reply, or excuse me, how to respond to a motion, is in the form, it tells you the same thing. It says, if you do not agree, this is what you need to do. So this motion is, again, for a temporary family law order, right? And it also includes a restraining order if you want. But it's also a great outline for any type of motion that you're going to file, whether it be civil, criminal, or domestic. Because the first and foremost, what you want to say in a motion is, who are you? And what are you asking for? And so you see in the mandatory form here, it states who you are and what you're asking for. It's saying we want the temporary orders. If it's a civil matter, you want to say the same thing and lay it out. Here, the second option, this is for the children. So if you have children involved in a domestic case, you want to include them here. And if you are asking the court to do something for some relief related to those children, like a parenting plan or such other requests. And then it discusses whether the other party is active duty military and the Service Members Civil Relief Act. And so, make sure you disclose that. And then this portion of the motion talks about the parenting plan and whether or not there's additional issues. And again, just like any motion, you want to be clear and concise and detailed. You notice that in this motion, they're not asking you for all the facts and the details. So whether you're writing a civil motion or a criminal motion, the motion portion of your filings is not detailed with facts. It is simply requesting relief. It's just like checking boxes. And so you want to make sure that you have checked the boxes or provided the court with exactly what it is you're requesting. The meat comes in form of the declaration, or in a civil matter, a lot of times it comes with what we call the argument and authority section in support of the motion. And so here, this is probably one of the most common clauses here in a family law motion, which is talking about the care and safety. Approve the parenting plan proposed by me. And that if you're looking for a temporary parenting plan, you check those boxes and then you provide your proposed parenting plan. Again, I'll go through this kind of quick, but it asks for, I won't asking for child support or spousal support, who stays in the home, what property do we use, whether it be personal property or anything else, whether you not need to protect property. Again, remember, this is a form, and the idea behind this form, and I think it's such a great example, is because all of the common requests to the court have been captured in this form. And so it does not include anything and everything. Remember, the law is always evolving. And so sometimes you got to utilize these forms and create your own request. And so again, household expenses, dividing debts, do not change insurance, whether or not you need fees and costs for attorney's fees, whether there needs to be a restraining order, and kind of the foundations of those, and it actually provides you with what else you need here. You know, whether it's be a weapons restriction, and then the actual restraining order itself when you're doing a proposed order. And then the reasons for my request. So this is your declaration. And so in a civil case, it's kind of your argument and authority, which is what the basis is. In domestic cases, the court is very in tune with the legal basis for request. There are a few statutes that you need to understand, and that's RCW 2609 or RCW 2619. Those two statute or RCWs that really cover your domestic cases for the most part. I mean, there's others, but for elementary terms, those will be a great start for you, getting parenting plan, temporary orders, child support, and such. And so here you see that you can actually provide a declaration, and I'll show you what that looks like as well. And they provide that. These lines are for that declaration. And then importantly, you need to make sure that you sign it, date it, because you are, this is your request. And so the court needs to know that you have signed off on it. And so once you've got your motion written, at least the motion portion of it, if it's in a civil case, a lot of times the motion will also include your issues that you're asking the court to resolve, along with the argument or the authority behind that supports why the court should grant the relief you're requesting, all in one. And then the declarations usually provide the evidence in support of that argument and authorities when you file. In family law, really, it's all because the court is in tune with what you're requesting in the statutes. It's not very case law heavy. It's more fact specific. And so it's important that your declaration contain the necessary facts to support your request. And so this is a different form, and it's not actually the mandatory form from for the family law cases, but it does the job. Again, you'll see different layouts. And remember, it's not necessarily the way it looks. While it's a mandatory form, you want to make sure what substance you need within that form to be successful. And so again, the caption is going to remain the same. You see this one, it's not centered, but that's okay. The court's not going to ding you for that. There are general rules related to how your pleadings are supposed to be prepared. And you should know that, especially in federal court, that if you do not comply with those rules as to what the size of font are, the indentations, they will reject your filings because of formatting. So remember, when we talk about the civil rules and local rules, make sure you look at the general rules as well to verify that you are following all of them, including formatting. In King County specifically, their local rule requires that there be a word count, and you have to attest to the number of words that you have provided and submitted in your documents, so you don't exceed the limit. In a declaration form, there are a couple important factors. One, you need to say who the person is, really what their age is, that they're over the age of 18, and what their relationship is to the parties or the action. Why is this important? Because it really breaks down and simplifies to the court who's testifying, how old are they, and what is their knowledge of this case. And then you have the remainder of the declaration is their statement, which is submitted under the penalty of perjury of the state of Washington, that they are attesting that the information they're providing is true and correct. And so some tips on filing declarations: again, do not just provide anything and everything, because the court does not want to hear about feelings. They want to hear about facts. And so I feel like you'd be a great parent. Well, the court appreciates those feelings. The court really wants to know, what have you observed objectively to make the court rule or allow the court to rule in a manner that is supportive of what's in the best interest of the child. And that's just utilizing a family law matter. And so remember, you have page limits. Use them wisely. And so you start off with the top of your declaration with who this person is, might be yourself, and what they're going to testify to, and then break it down into each aspect of your motion, the relief you're requesting. So it simplifies it for the judicial officers. So when you're looking at your motion and you're asking the court for financial support, in your declaration, you should have a financial support section that will identify everything that the court needs to address this request for support. And so the court, it's organized, and the court can look at the declaration and determine, okay, here is the issue I have related to financial support, and here's all the evidence. If you're skipping around in your declaration, you're not concise, and you don't provide the necessary evidence, then it's very difficult for the court to make a ruling on the specific relief that you have requested. And then lastly, we get into orders, right? And temporary order. Again, it is imperative. And a lot of people don't do it. But if you want to have a higher chance of success on a motion, provide the court with your breakdown of everything you're asking for. And that is in the form of a proposed order. Here you will see this is a form, right? But it's a great template, even if you're doing a civil motion or a criminal motion for proposed order. In every type of law, there are some motions that have templates, and there's some that you just have to draft from scratch. There's some motions that have proposed orders that are templates, and then there's some that you have to draft from scratch. Excuse me. So again, the caption is going to be the same. And here you have, and this is pretty standard in all family law cases, you have a money judgment summary at the top. It is important, and I repeat, very important, that you indicate in your caption as to whether or not the relief requested is going to take some action of the clerk. Because if it is, and you do not indicate in the caption that clerk's actions required, it is likely it will be missed by the clerk because they don't have notice that they're supposed to do something with the order as well. And here you'll see, number one, whether or not the clerk is supposed to enter a judgment against a party. And if you are, or they are, they would mark this box. The probably second most important aspect of a temporary order are the findings of the court. Now you may ask yourself, how do I enter findings if I don't know what the court found? Well, this is what you are asking the court to find in your proposed order. So be specific. Take the time to draft an order, a proposed order, that identifies everything that the court finds in order to reach the conclusion, which is the order of the court. And in family law cases, if you're asking for restrictions on an individual, make specific findings related to that individual and what the court found. For instance, if somebody's been alleged to have substance abuse issues, it could be great to insert findings that support an order for that person to have supervised visitation, to get evaluations, or any other such relief related to a finding of substance abuse. In civil matters, it is great to utilize findings in your proposed orders to set up your case for future hearings and to identify or resolve facts or elements that you have to establish in order to be successful in your case. And so findings are usually very overlooked, but are very powerful in the orders. And so find out what it is that you need, the elements to prove or to establish the relief you need, and identify those in your proposed order. And you will see that majority of practitioners and pro se individuals don't include any specific findings. And I think that's a huge error in the field of practice. Again, there's got to be a finding here of the military status, and then you get into the court's order. And so when you're drafting your proposed order, the layout should be just like this. The caption, really any clerk's actions, and the findings of the court, and then what the court is ordering. And so here you can utilize, if the court is making a order on a parenting plan, you'll see here that the care and safety of the children is included, whether or not there needs to be a guardian ad litem, and providing support, who's going to stay in the home, the use of property, again, whether or not these restraints are going to be implemented. And I can tell you that in the scheme of family law, nearly every county now is going to issue temporary restraints that basically say don't do anything outside of the ordinary. They don't want people cutting off insurances or spending money they shouldn't have or selling things. The idea behind it is that commissioners are able to get the case as it is when it's filed to the trial judge without dissipation of assets or increasing the debts of the parties, so they can make a ruling that's fair and equitable. And again, one of my recommendations when presenting an order is don't include additional language that's not necessary. It's tough enough to look at an order with all of this language and extra on here. But if you do not have children and you're not asking for relief from the children, remove all of this form language. So it simply says no request made. It allows you to be able to look at your order and see quickly what it is the court is ordering and what they have signed off on, without having to dig through, well, was this accidentally checked? Was it not accidentally checked? And also in the context of family law, by removing the extra language, it also reduces the chance that the judicial officer may make a different order or different finding against you. And so you're giving them one option. They don't look at it and see, oh, well, maybe I'll check this box too. And you may not want that. So give them exactly what it is you want. Remember, it's a cheat code. It's telling them, look, all I'm asking for is A, B, and C. And then that makes their job really easy, because they can look at the facts that you provided and the evidence thereof and make that order. Finally, when you get down here, just as any civil case, it is okay to ask the court for any type of relief that's not contained in this order. And the reason for that, this is the catch-all of what is it that you're asking for. and why I think family law motions are very helpful when learning motion practice and for people in family law is because they have captured in their mandatory forms almost all the most common motions that are made before the court. It is not perfect. There are times where the only request you're going to make or the only order that's going to be issued is in section 14, and that is requesting relief. And so these forms really provide a great basis for motion practice to see how to draft an order, see how to draft a motion, and provide that to the court. And so I'm going to switch back here now to, now that we have seen what it looks like. If you have any questions related to the motion practice or what it is you're supposed to do, please don't hesitate to reach out and ask questions. Again, once you have your note, your motion, your supporting declarations, and your proposed order, you will go in and file with the system that the county uses, or in person in some cases. And once it's been filed, you need to make sure that you not only serve the other party, but that it's provided to the commissioner, judicial officer, the judge through a bench copy or working copy, and that you really follow those deadlines. Again, this is simply a primer on filing motions, utilizing the family law case, which has forms. It's meant to help you recognize the basics of it, and that is the note, the motion, the declaration, and a proposed order. And so if you have any questions, feel free to reach out, and it's been a pleasure. Thanks for having me.